Now for me. Mr. Shears, I've found it interesting that one of the things we haven't gotten too much into is Mr. McKnight's question. From your knowledge, technical knowledge, forgetting about how something is blocked, when Mr. Knight puts in a notice and takedown, is there any reason that it should not be able to be done in single-digit minutes, as it sometimes is, or even faster today, based on technology?
So the ability of a given service is going to respond to takedowns is going to vary depending on the context, the nature of the work, the scope of the takedown. You know, it's not uncommon for a rights holder to submit millions of URLs, some of which may not be accurate. And because every takedown does terminate access to expressive content, there are consequences for getting things wrong. And so I know many services are instantaneous. A lot of services that allow rights...
Wait a second, I didn't ask that question. I only asked, is there any technological reason that it can't be done instantly?
When access to content is terminated, if you remove...
You're getting into the ramifications. Maybe I'll clarify my question. If we, I think, can all agree that the technology using AI is available for Mr. McKnight to submit, for it to be validated against metadata comparison if he's making that data available through his live stream, the idea that it can be compared and identified and taken down essentially without human interaction would seem to be unequivocal. So it sounds like there may be administrative reasons that an entity can respond to why they're not taking it down. But as the entity that created the original notice and takedown and the entity that can update it, as Mr. McKnight is asking us to, is there any reason we shouldn't update a requirement that it either be taken down using that technology, which is near instant, or that he or any company receive a response within the same period of time as to that which delays it? That's what I'm asking. It's much more narrow than the other subjects we're talking about, because we're not talking about do you have the capability. We're assuming the capability exists because it does exist for notice and takedown. What is your response to that? Either do it or respond near instantly.
I think we agree that an expeditious response is appropriate, particularly where there's economic consequences like have been described. And of course, Section 512 already requires expeditious response. There has been some litigation about what that means in practice.
Well, we're real good at eliminating the need for litigation by redefining to the courts what we really meant. It sometimes saves the court a lot of trouble. Let me just go on with another round of questions. Ms. Temple, you've heard a lot here, and you certainly saw us say we don't want to have SOPA and PIPA revisited. We want to have full and complete. But, and I want to leave free speech in another bucket, but I want to ask you a question. Based on the actions of these internet providers of using their protections under 230 to regularly take down infringing content that you often see, in other words, Mr. McKnight and others, even Mr. Shears has said that providers do it, what lawyers say, sua sponte. They do it without a complaint often, and they do it with a reasonable protection. If they can do it without a complaint, as they often do by matching, is there any reason that we shouldn't encourage them to do it more often or substantially all of the time?
Yeah, if you're talking about filtering and ensuring that illegal content is not posted up on UGC sites. That is something that, certainly we want them to do more of, and we want to have more automated ways that you don't have to send the millions and millions of notices that the other witness mentioned. With respect to dedicated websites, of course, it's much, that are dedicated to infringement and are not UGC sites where people are posting. It is much more complicated because those websites are not going to take down the infringing content. They're not going to filter it out because they're dedicated to piracy.
Well, let me close with just a couple of questions. And Mr. Gladstein, I haven't asked you any questions, but I'm going to ask these questions in a sense on your behalf as a producer of content that finds himself somewhat harmless or harmed without any ability. I might note that one time I had dinner at a large banquet, but we were at the end of the table, and it was Francis Ford Coppola who bemoaned how little control he had over Godfather 3, and if he'd only had more control, how much better it would have been. So it's not just the fire and forget. Sometimes it's even when you're producing it. But Ms. Temple, because you have this unique expertise on both sides of it, why don't I just ask a few simple technical questions? To the best of your knowledge, when somebody imports a tangible product that violates IP rights, including patent, trademark, copyright, does the U.S. Customs have the authority to stop it?
Yes, it does.
And when a court or the ITC issues either an exclusion order in the case of the ITC, agencies have the ability to use their powers to stop the importation of those products.
Yes, they do.
So today, as a closing question, aren't we just talking about finding the equivalent of what for 200 plus years our customs and other agencies have done when there is due process and entities such as Article 3 courts have reached a decision? The execution of that protection is done by our government or on behalf of our government by orders to those who participate in bringing things into the United States.
Yes, I would agree. That's a very similar process.
So as we invite the Department of Justice, which was suggested, and as we re-invite those who chose not to be here today, those who can talk to us about, and Mr. Shears, I appreciate your expertise, but I want to have more of those entities in here to talk about what is technically possible, not just what is technically difficult, because it is this committee's jurisdiction and this committee's decision that which we protect through our ports of entry when a DVD comes in, bootleg, we must be able to protect on the internet. If we do not have that ability today, it is our responsibility to create that ability. And I want to close by just making one statement. I know there have been good faith negotiations that have gone on behind the scenes. I have been told that those negotiations broke down to a certain extent because of hold harmless questions in our very litigious society. It is also the jurisdiction of this committee, at the full committee level, to provide that type of protection. So let's be clear that in getting it, I'm aware that if you get a court order and Customs seizes DVDs coming into the country, everybody's held harmless. There is, in fact, a government right to do so, and all you can do is maybe get your DVDs back later if there was a mistake. You don't get to litigate against the person who brought the claim in court. What is possible in the tangible world, I want to put on notice those that we're going to have in follow-up. We want to find a solution in the internet world, and we will not quit under this committee, and including my ranking member to my left and my full committee ranking member also to my left, until we do so.